the building approval that had been withdrawn. The claimant replied the query, and after about a month, a letter of warning was issued again over the building approval. The claimant testified further that after he was deployed back to Kaduna, the secretary to the state government held a meeting with the staff of the defendant. That at the meeting, 3 of the members of staff of the defendant were recommended to be issued queries for improper discharge of their duties. But the committee constituted for the investigation without a formal query included the claimant, and that while on annual leave, another committee was constituted and another query was again issued by the new committee. It is the further testimony of the claimants that while still awaiting the outcome of the queries or the reports of the committees, he received a letter of suspension for 1 month without pay, that is between 1st of January 2018 to 31st of January 2018, this being the outcome of the second committee, that while still serving the suspension, the third committee issued another letter of indefinite suspension, and while on indefinite suspension, received a letter of termination of his appointment on the 20th of September 2018. The claimant appealed against his unlawful termination of his appointment and contends that the queries were maliciously issued, that the committees were improperly constituted, contrary to public service rules, and the proceedings of the committee grossly violated his rights of fair hearing as prescribed by guidelines for appointments, promotion, and discipline of staff of Kaduna State Civil Service Commission. Abdullah Idris and Lawal Yusuf, the head of administrative department and the chief town planning officer of the defendant, were subpoenaed and they testified as CW2 and CW3 respectively. While CW2 stated the procedure for inaugurating and constituting investigation and disciplinary committee in its testimony, CW3 on his part stated the procedure for approval or permission for development of land. To further support his case, the following documents were admitted in evidence. 1, letter of offer of temporary appointment and letter of confirmation of appointment, Exhibit C1, Exhibit C2, queries dated 3rd of May 2016 and 22nd of December 2017, Exhibit C3 and C3A, 3, letter of warning and letters of suspension dated 9th June 2017, 27th December 2017, and 17th of January 2018 as Exhibit C4, C4A, and C4B. 4, letter of termination of appointment dated the 12th of September 2018 as Exhibit C5, 5 minutes of meeting held at the office of the Secretary to the State Government on the 3rd of August 2017 as Exhibit C6, 6, interim report on the demolition notice issued on constituency projects at Nkuyi on 2nd August 2017 as Exhibit C7, report of committee set up to investigate allowing of a development to be erected up to painting level at Nkuyi and Kudan towns as Exhibit C8, committee's report on the investigation on the alleged negligence of duty by Stephanus Kato Inyam as Exhibit C9, reply to queries dated the 4th of May 2017 and 22nd of December 2017 as Exhibit C10 and C10A, attended list of 3rd August 2017 as Exhibit C11, and letter of withdrawal of planning permission dated the 2nd of May 2017 as Exhibit C12, letter of appeal of termination from service dated the 18th of October 2018 as Exhibit C13, notice to owners of undeveloped and uncompleted properties as Exhibit C14, reply of the defendants for application for certified true copy as Exhibit C15. Now it is stating the obvious to affirm from the onset that from the evidence on record, the employment relationship between the claimants and the defendants is regulated by statute. This is clearly seen in that the defendant, per paragraph 2 of the amended statement of defense, positively admitted the averments in paragraphs 1 and 2 of the claimant's statement of facts. Essentially, the grounds of the claimant as stated in paragraphs 37, 38, and 39 of his statement on oath, is that in terminating his appointment, the defendant did not follow the prescribed rules and guidelines, and the proceedings of the committees grossly infringed his right to fair hearing. The submission of learned claimants counsel is that the way and manner prescribed for the termination or dismissal of statutory employment, such as the claimant's employment, must be religiously observed, otherwise such termination has no effect whatsoever, and the employee will be deemed as continuing in his employment. See the cases of Adeniyi versus University of Lagos, Iderima versus Rivers State Civil Service Commission, and Bob versus the Council, Abia State University, Uturu, and another citation also applied. Learned counsel argued further that mere issuance of a query to an employee does not amount to an indictment or punishment, and submitted that the method of dismissal, the method of termination by the defendant against the claimant is contrary to the rules prescribed in Kaduna State Public Service Rules 2005 and in the guidelines of appointment, promotion, discipline of the Kaduna State Civil Service Commission. Learned counsel for the claimant submitted further that the claimant was not given opportunity to defend himself or call his witnesses, or afforded with all the documents for his defense, or accorded fair hearing, and also submitted that the committee was improperly constituted, as same was chaired by the head of department of the claimant. Learned counsel finally urged the court to hold that the procedure culminating to the issuance of the purported letters of suspension and termination of claimant's appointment is unlawful. To buttress the submission, learned counsel cited the cases of Eze versus Unijust and the case of UTC Nigeria PLC versus Peters, citation supplied. Now, by the evidence on record, particularly as contained in Exhibit C6, the minutes of the investigation held in the office of the Secretary to the State Government, and Exhibit C7, the interim report on the demolition notice, a recommendation was specifically made for the issuance of query to 3 of the members of staff of the defendant who were directly involved in development control activities, namely Awa Ladan, Aliyu Usamatu, and Kassas Zachariah. However, contrary to the recommendations and by the report of the committee set up to investigate the development activities, that is Exhibit C8, a query was issued to the claimant alongside with the 3 members of staff. It is equally on record that the claimant was issued 2 queries, that is Exhibit C3 and C3A, and his reply to the queries are contained in Exhibit C10 and C10A. Despite his reply to the queries, the defendant arrived at the decision that the claimant committed 3 offenses and was awarded with 3 punishments, namely 1, warning letter issued on the 9th of June 2017 for granting approval on a carved out plot at number 77B, Western Way Close, GRA's area, that is Exhibit C4. 2, 1 month suspension with effect from 1st of January 2017 for allowing developments as Nkuyi and Kudan, that is Exhibit C4A. 3, indefinite suspension with effect from 17th of January 2018 for negligence or refusal to discharge his official duty diligently at Millennium City Area Office, Kaduna, that is Exhibit C4B. Undoubtedly, the right to suspend an employee is available to an employer in order to effect proper investigation. There are both foreign and local judicial decisions approving suspension of an employee pending the final determination of his involvement in the allegation leveled against him. So the case of Esiaga versus University of Calabar, 2004, Law Pavilion Electronic Law Report at 1109. Therefore, the claimant was lawfully suspended by the defendant pending the outcome of its decision, but the discretion to suspend must be exercised with a good sense of duty. The defendant's right to suspend his staff as provided for in Part 4, Rule 7.5 of the Guidelines for Appointments, Promotion, and Discipline. It provides as follows, and I quote, "Under no condition should interdiction or suspension be made to last more than 3 months in the first instance. Where the need for arises, the permission of the State Civil Service Commission shall be obtained." End of quote. As stated above, the right of the defendants to suspend its employees is not indefinite. From the unchallenged facts and evidence, the claimant was placed on suspension in Exhibit C4A and C4B, respectively, on the allegations that border on allowing development to be erected up to the painting level at Inkwi and Kudan towns, and negligence or refusal to discharge his official duty diligently in the Millennium City area. While the claimant was serving his suspension for the allegation in Exhibit C4A, which suspension was for 1 month without pay, he was placed on indefinite suspension in Exhibit C4B with effect from 17th January 2018. His appointment was terminated on the 12th of September 2018 while he was on indefinite suspension. Learned Claimants Counsel contends that in spite of the claimant's replies to the queries, the defendant neglected the defense of the claimant, as stated in his replies to the queries, that the defendant did not write to the claimant to notify him whether the reasons that were stated in his reply were sufficient or not, and he was not requested to make further representations as prescribed by Rule 04302 of the Kaduna State Government Public Service Rule before his suspension and the eventual termination of his appointment. Now, as I earlier stated, the claimant's employment is regulated by Kaduna State's Public Service Rule. In view of its relevance to the determination of this case, I find it necessary to refer to Rule 04305 of the Kaduna State Public Service Rules relevant to this case at hand. I have taken liberty to reproduce the said rules as follows. I quote, "If it is represented to the Civil Service Commission that an officer has been guilty of misconduct and the commission does not consider the alleged misconduct serious enough to warrant proceedings under Rule 04306 with a view to dismissal, it may cause an investigation to be made into the matter in such manner as it's considered proper, and the officer shall be entitled to know the whole case made against him and shall have adequate opportunity of making his defense. If, as a result, the commission decides that the allegation is proved, it may inflict any other punishment upon the officer, such as reduction in rank, withholding, or deferment of increment or otherwise." End of quote. I must reiterate that the effect of the above provisions is that the claimant cannot be validly removed from the employment unless the provisions provided in the statute for removing him as stated is followed strictly. See the cases of Adeniyi versus University of Lagos, Okoswidi versus Ladoke Akintola University, citation supplied. It is equally settled that for the dismissal to be unlawful, the claimant must prove that there was a departure from the prescribed procedure, or that in applying the rules, there was a violation of the rule of natural justice so as to render the formal compliance a travesty. The courts have held in a plethora of cases that the real issue where the question of fair hearing has been raised is whether an opportunity of hearing was afforded to the parties entitled to be heard. And by hearing, it means full hearing, which includes allowing the parties to put in all they have. See the case of Yusuf Garba and others versus University of Maiduguri, 1986, One Nigeria Weekly Law Report, Part 18 at page 550. The unchallenged evidence before the court is that the claimant was not afforded the opportunity by the defendant to present his defense. As seen in Exhibit C5, the immediate termination of the claimant's appointment was based on, I quote, the board of Kasud Pass decision at its meeting held on the 16th of July 2018, end of quote, by the Kaduna State's Public Service Rules. The representation must be made to the commission, and the decision to terminate an appointment must be made by the commission and not the board. I should also note that the letter of termination of appointment was dated the 12th of September 2018, that is 2 months after the board made its decision. The claimant's testimony is uncontroverted and remains sacrosanct. Therefore, the court has no difficulty in believing the same, more so since no aspect thereof appeared incredible. With the foregoing facts and evidence, it is clear that the defendant did not observe the prescribed procedure for the suspension and termination of the claimant. Therefore, the claimant has successfully established that the termination of his appointment by the defendant is unlawful and void, and I so hold. In the event, the letter of termination of appointment dated the 12th of September 2018 is hereby set aside. I further so hold. It is right that where there is an improper removal of an employee from an employment protected by statute, the consequence is that the employee has not been removed from office, and the court will void the unlawful act and order the reinstatement of the victim of the capricious exercise of power. The cases on this point are legion. I will cite only 3. Kwara Polytechnic Ilorin versus Eyebanchi, Maliki versus Michael Lumodu Institute of Labor Studies, and Shitabe versus FCSC, citation all supplied. In the instant case, there is nothing legally standing in the way of the claimant from having his job back with its attendance rights, benefits, and privileges. On the basis of the uncontroverted evidence on record, therefore, and the settled position of law, it will be appropriate in the circumstances of this present case to grant the claimant's claims. I hereby grant the claimants the following reliefs. 1, a declaration that the decision of the board of the defendants at its meeting held on the 16th of July 2018 in the termination of the claimant's appointment is contrary to the rules as contained in Kaduna State Public Service Rules 2005 and the guidelines for appointments, promotion, and discipline of staff rules issued by the Kaduna State Civil Service Commission, and is therefore null and void. Two, a declaration The determination of claimants by the defendant via the letter of termination of appointment dated the 12th of September 2018 is unlawful, null and void, and of no effect whatsoever. 3. An order of this honorable court reinstating the claimants in the services of the defendant. 4. An order of this honorable court directing the defendants to pay the sum of 3,531,685 naira 65 kobo only within 1 month, being arrears of salary and allowances at a monthly sum of 51,183 naira 85 kobo only from 12th of September 2018, the date of the purported termination of the claimant's appointment, till date. 5. Costs of 500,000 naira is awarded in favor of the claimant. 6. It is hereby further ordered that the defendant shall pay to the claimant the sum set out in 4 and 5 above within 30 days. 7. 10% interest is awarded on the judgment sum from the date of default until final liquidation of the judgment sum. Parties shall bear their respective costs.
Lord, judgment of this honorable court.
Thank you. The judgment will be posted on the portal of the judgment of the NIC. I don't know when I can transmit the hard copy. I will do so as soon as possible, but you can always access it from the portal, please. Thank you. Yes, the next case.
Case number 2. NICN/KD/0320/2020 between Shitu Sabiu and National Research Institute for Chemical Technology, Zaria, and 3 others. My lord, parties absent.
Parties absent, appearances, please.
Humility, respect, my lord. And H.M. Nasir, announcing my appearance for the claimant.
H.M.
H.M. Nasir.
Nasir. S-N-A-Z-I-R.
No, my lord. N-A-S-I-R.
Okay. Thank you. Nasir. For the claimant.
For the claimant, my lord.
Yes.
Yes, with profound humility, my lord. A.T. Abubakar.
A.T. Abubakar.
My appearance is for the 1st, 3rd, and 4th defendants.
Yes. Any representation for the 2nd?
Yes, he's online, but he has muted himself. Michael. Michael, unmute yourself.
My lord.
Yes.
With profound respect to this honorable court,
yes.
My name is Dong Long. My humble appearance is for the 2nd defendant.
Your last name is spelled how, sir? D-U?
D-O-N-G.
D-O?
D-O-N-G-L-O-N-G, yes. My lord.
Okay, thank you.
My humble appearance is for the 2nd defendant, my lord.
Yes. Yes, what's the position of the case, please?
Yes, my lord. The matter slated for today is for adoption.
Who am I talking to? Can you identify yourself? Is it the 2nd defendant or the 1st defendant? Mr. Abubakar, are you the one making the submission?
No, my lord. I think it's a claimant counsel.
Okay, let me maximize it so that I can see who it is. The claimant counsel, yes, what's the matter for, please?
Yes, my lord. The matter slated for today is for the adoption of written address. However, we are not ready.
You are not ready. We are not ready. Why are you not ready?
Reason being that, my lord, we have an application before the court.
What application is that?
Yes, my lord, the application is dated yesterday, filed today, seeking for 4 orders as contained on the face of the motion.
Is it the same order of the, as the last order for the court to recuse itself?
It's included, my lord, but not the same.
Can you read out the order? Since you are just filing it this morning, so I do not have a privilege of looking into the application.
Yes, my lord. Order number 1 is explained to this honorable court.
Yes, I'm listening.
Excusing/recusing itself from hearing and determination of the case.
Yes.
She to serve National Research Institute for Chemical Technology and 3 others.
Yes.
With the suit number NICN/KB/03/2020.
Yes.
The second order of this honorable court is praying for this honorable court to remit the case file in the instance suit to the new presiding judge, National Industrial Court of Nigeria, Kaduna Division.
To remit the files to the judge. To remit what?
An order of this honorable court remitting the case file in the instance suits to the new presiding judge, National Industrial Court of Nigeria, Kaduna Division. The third order of this honorable court, that the National Industrial Court, Kaduna Division, shall proceed with the instance suit by virtue of the National Industrial Court Rules 2017. And for such further orders as this honorable court may deem fit to make in the circumstance of this case.
Okay, so you deem it's proper for you to just file this application this morning when the case is coming up this morning?
Yes, exactly. We are sorry for the, and we intend to withdraw the all motion.
I didn't hear that.
Yes, we intend to withdraw the all motion.
Okay. Can I hear the defense, please?
Hello, pardon, sorry, my lord.
Claimant, are you still talking?
Yes, my lord.
Yes.
We are yet to serve the defendant with the new application. And in view of the circumstance, we shall be craving the indulgence of the court. Grant us adjournment to be able to serve the defendant in the matter, and we are sorry for all the inconveniences we may cause to the court. This is our humble application, my lord.
Yes.
My lord, sir.
Yes.
With profound respect, R.M. Donglong for the second defendant, my lord.
Yes.
Well, my lord, on our part, we shall be objecting to the application of the claimant because of the fact that we've joined issues with respect to the first motion that they filed. Secondly, this motion that they are filing today, my lord, they have enough time to file and serve, but they deem it fit to file it today. Is more of an ambush. As such, we'll be objecting to that, my lord. We've not been served. We are not aware of any motion like that, and we are ready to move our counter affidavit, which have been filed since last year, my lord. That's our humble application.
Yes, do I have any submission from the first defendant?
Yes, sir. I wanted to react before my colleague. My lord, we vehemently object and oppose that application, my lord. This matter came up last on the 24th day of April. The claimant sent in a letter asking this honorable court for an adjournment, and they did not deem me fit to file any process at that time. And this court has ordered that the matter be adjourned despite our opposition to today's date, to either take their motion or to adopt the written addresses.
Yes.
And they failed to do any of that one. And besides, the motion being filed this morning is the same with that file at that is in the jacket in the file of my lord. It's the same motion. This is just a plot to delay these proceedings, my lord. My lord, we urge this honorable court to refuse that application and proceed for the business of the day, my lord. To proceed with the business of the day, my lord. That's my humble application, my lord.
Yes, do you have further submission, claimant counsel?
Yes, my lord.
Yes, what is your further submission? Yes.
We refer this honorable court to the case of Atanda versus Adeniyi.
What does it say?
My lord, it is a tried law that when a matter is that court is bound to hear and determine all applications.
Okay, I will determine it here and here. If it is tried that court should determine application. Are you aware that an application was sent to the president that the president should transfer this matter?
I'm not, ma'am.
Okay, you will talk to your substantive counsel. An application was made to the president, by your letter from your chambers, dated the 8th of November 2023, requesting for the withdrawal of the case from NIC and Kaduna Division and reassignment to another judge or division pursuant to the order made in the letter. The president of the court, by the letter dated the 24th of November 2023, stated that the application not granted, that the case should proceed with this court. So your application coming right now has been overtaken by events, and therefore I will not consider this motion that you are presently filing.
I'm sorry, my lord. I'm sorry, my lord. This application is brought fashion to the use of this honorable court.
And why did you write to the president when you know it is brought pursuant to the rules of the court?
I'm not aware of that.
And the president has directed that this matter should proceed with this court.
As the court pleases.
I'm sorry, my lord.
Court pleases.
And in any case, you cannot. Your prayer too cannot be granted on the ground that it is not by the rules of the court, because by the rules of the court, the case should be taken to the president, to remitted to the president for transfer. A case cannot be transferred in between judges. And because the president of the court had directed that the application that you made earlier is refused and that this court should take this application, so this application is inconsequential. Yes, can we have the matter for adoption? The matter for today is for adoption. Thank you.
As the court pleases. As the court pleases.
As the court pleases.
As the court pleases.
Can you take your adoption, please?
I'm ready, my lord.
Yes, you can.
As I made my application earlier, we are not ready for that application because we withdraw the application.
This application. There's no application. There's no application before the court. Like I said, it has been overtaken by events, by the reason that you wrote to the president that the case should be transferred, and the president had written that the application is refused. So there's no pending application before this honorable court. It has been overtaken by events.
I'm sorry, my lord.
As the court pleases.
As the court pleases.
My lord, this honorable court is bound by the decision of the Supreme Court, my lord.
Which Supreme
and
Court?
It is,
on what case? In which case? I'm not bound because you can distinguish cases. I'm sure the case that you want to cite now did not emanate from the National Industrial Court. It must be a trial, the trial court must be a high court or federal high court. I'm not bound by the rules of the high court or the federal high court. So that case from the Supreme Court is distinguishable because we are not acting on the same parallel. We have different rules that binds the court. Yes. If the defendant is ready for the adoption, you are muted, Mr. Abubakar.
So, I am ready, my lord.
Yes,
my lord, we are
ready, my lord.
Second defendant is ready, my lord.
I will make a record. Let me just record all these things that's transpired.
As the court pleases. As the court pleases.
And make a ruling.
As the court pleases.
As rightly submitted. Court as rightly submitted by the defendant counsels in this matter. The matter is for adoption of written address. The claimants had filed a motion on the 6th of February 2023, which had been pending up till now. However, during the pendency of the said motion, the claimant made an application to the Honorable President of the National Industrial Court of Nigeria requesting for withdrawal of the case from National Industrial Court Kaduna Division and reassignment of the same to another judge of the division. The letter is dated the 8th of November 2023. On his reply of the 24th of November 2023, the Honorable President of the National Industrial Court of Nigeria refused the application for transfer. In other words, the application pending is overtaken by events and is hereby accordingly struck out. The present application filed today is essentially praying for the same orders as the former application. Indeed, it is interesting that it is the claimant who is bringing such applications for the case that had been commenced since 2020. It is said that justice is not only for the claimant, but for the defendant and the society at large. The court shall proceed with the business of the day, which is for adoption of written addresses.
As the court pleases.
Yes.
As the court pleases. My Lord, sir, we are ready to adopt the process, our process filed before this honorable court.
Thank you. When was it deemed properly filed? Can I have it?
Well, my Lord, it wasn't deemed due to the fact that this particular motion has not yet been taken. But since it has been taken today and ruling has been...
I have my record straight here on the what date is it?
My Lord,
on the 10th of October. Application granted. Time is hereby enlarged within which the second defendant may file and serve the counter affidavit in opposition. They already filed, okay?
Yes.
It has not been deemed filed.
It has not been deemed filed yet, my Lord.
Okay, you can move your application. So they still have a time within which to file the address if they so wish, because it will be running from today now.
Yes, my Lord.
Move your application for extension of time.
As the court pleases. My Lord, on behalf of the second defendant, we have a motion on notice brought pursuant to Order 57, Rules 4, Sub 1, 2, and 4 of the National Industrial Court Civil Procedure Rules 2017 and under the inherent jurisdiction of this honorable court. My Lord, The motion
and as
is
far as
praying.
I'm concerned, I don't have even this present application before me since it was filed today. So there's no application before the court.
As the court pleases. As the court pleases. But my motion wasn't. My motion wasn't filed today.
I'm referring to the thing that they said they filed today. It is not before the court.
Okay. As the court pleases. As the court pleases.
Yes. Yes. We have a motion pursuant to Order 57, Rule 4, 1, 2, and 4. Yes.
The motion is praying for an order of this honorable court enlarging time within which the second defendant/respondent may file and serve his final written address. 2, an order deeming the already filed final written address as duly filed and served. And for such orders or further orders as this honorable court may deem fit to make in this circumstance, my lord. My lord.
Same as been served on the claimants?
It has been served, my lord. It has been served on the parties. The claimant and the first, second, third to fourth defendant. All of them have been served, my lord.
This application was filed on the 12th of September?
Yes, my lord, 12th of September 2023.
Yes.
It is accompanied by a 9-paragraph affidavit deposed to by Ibrahim Indiji, a litigation secretary in the law firm of the second defendant, my lord. We rely on all the disposition of the affidavit. And in compliance with the rules of this honorable court, we also filed a written address dated the 7th day of September 2023. My lord, we adopt the said written address my lord, sir. My lord, sir.
Yes, sir. Yes.
Okay. We adopt the said written address.
Yeah, I heard you. And now it's the court to grant the application.
And we ought to be to grant our humble application. That is our humble application, my lord.
Yes, thank you. I'm writing the ruling.
As the court pleases. We are much obliged, my lord.
There's no counter affidavit against it, so I'm writing a ruling.
As the court pleases, my lord.
Court application granted. Time is hereby enlarged within which the second defendant may file the written address. The already filed and written address is deemed as properly filed and served.
As the court pleases. We are
first, third, and fourth defendants, you said you are relying on the second defendant's address?
Yes, sir.
First, third, and fourth defendants, we are relying on the second defendant's address. Thank you. So the case is adjourned. The claimant has 21 days within which to file the address, if they so wish.
As the court pleases.
As the court pleases. Most obliged, my lord.
So the case is adjourned. What's today's case? 8 plus 7, 8 plus 7, 15, 15 plus 7, 21, 21 plus 7, 29.
Sorry, ma'am.
Case is adjourned to the 3rd of June, 2024 for adoption.
As the court pleases.
As the court pleases.
Most obliged, my lord.
Third of June 2024. Yes, for adoption. Thank you.
As the court pleases.
As the court
We are
pleases.
grateful, my lord. Most obliged,
Yes,
my
the
lord.
court will rise. Thank you.
Thank you for indulging us, my lord.
You're much obliged. I'll start you with my applications.
This same guy, you again.
With my application. 80 is my boss. We are together in Zaria.
You again, I know you. You are
no problem.
all these applications.
Don't mind him. They want to hold us to ransom.
You want to
instead
hold
of them to.
This guy, where is your boss?
Let's finish this case and move on now. If you are not satisfied, you can go upstairs.
You can go upstairs. There are people like that. If you're not satisfied, you can go upstairs. You don't have to be dragging us.
No, we are not dragging.
Dragging us. We want to finish this thing.
We want the court to comply with the rules of this honorable court.
When you've already written a letter.
It's not a do or die idea.
No, you file an application before the court. You went ahead and wrote a letter again. That's an abuse of court process now.
And then you filed the same application.
They will have dismissed the whole thing.
He also filed the same application, repeating the same prayers.
No, it's not the same application. So
you see, we are not even aware that you will file an application to the president. We were not copied.
I'm hearing it for the first time.
Well, your principal did not tell you the truth. He wrote a letter after filing an application. Why did you go ahead to write another letter again? That's an abuse of court process.
He is making a separate fight. He allowed this fight for me to handle. He's making another. He's making another application somewhere.
He has done the dirty job and left it for you to come and fight the dirty fight. Instead of him to come and fight it himself after you have spoiled the whole thing.
But my lord says she is not even aware of this application, so we are going to make it formal.
No problem. After she has already ruled that it has already been overtaken by event.
So she said,
all right, safe 3.
She is not even aware of the application. Thank you, sir.
This is finally little address. Let's go.